in the name of personal injury law.
In 2019, the Michigan no-fault insurance law was drastically changed in many ways. Some of those changes took effect at different times. Some of them just went into effect on July 2, 2021. We have Steve Sinas here from the Sinas Law Firm to talk to us about where things stand now. Steve, it's great to have you on the show.
Thank you very much for having me. It's great to be here.
Okay, Steve, so what were the changes that went into effect on July 2nd, 2021?
All right, so the Michigan no-fault insurance law has always been complicated. After these reforms, it's become even more complicated. And one of the things that's hard to understand is all these different ways in which it's been changed and when those changes go into effect. And what we have here on July 2nd, 2021 is a date that marks the beginning of the new rules regarding how insurance companies must pay for the care and treatment for people who've been injured in an auto accident. Let me quickly explain. Under the old law, prior to the reforms, insurance companies had to pay for people's medical services related to their auto injuries. They had to pay their providers a reasonable charge. So the providers had to submit their bill, and the insurance companies only had to pay an amount that constituted a reasonable charge. Now, as of July 2nd, 2021, the rules have changed in a very significant way. It's no longer about the insurance company having to pay a reasonable charge. There's a cap on the amount they have to pay. And that cap it can be complicated in terms of exactly how it is calculated and how it applies to every single medical provider. But suffice to say that for many medical providers, especially those who are providing post-acute care and rehabilitative services to the most catastrophically injured, they're being told that they can receive no more than 55% of their charges that were in effect on January 1st, 2019. So if a person's injured in an auto accident and they go treat with one of these providers, the bill gets submitted to the insurance company. And now what the insurance company is able to do is say, okay, we can demand what your charges were on January 1st, 2019 for those services, and now pay you only 55% of what your charges were back then.
So
and
many medical economic impact.
It's a huge economic impact. And so medical providers are really fearing their ability to stay afloat under these new rules. There are a lot of medical providers here in Michigan that have specialized in treating auto accident survivors under the no-fault insurance system. They've developed their business around their rates of reimbursement, and now they're being told that they have to operate receiving 45% less from the insurance companies going forward. So it's a huge impact on the providers, and in turn, it's a huge impact on the patients, because without their providers, they don't get the care they need. So the reduced rates of reimbursement are a huge controversial issue, and there's a lot of efforts underway to try to hopefully bring about some change to that drastic reduced reimbursement rate. But right now, it hasn't actually materialized in the way we hoped it would.
Well, two questions. One, I heard that some of the providers are having to close their businesses because they can't afford to operate. Is that true?
Yes, I know of several businesses that have decided to close their doors because the prospect of having to operate and receive 45% less was a one-way ticket to becoming a bankrupt company. So they just decided to close their businesses. Many more are fearful that they will. And if I may, what was your other question, Lisa?
Well, you mentioned that there are some possible fixes in the work, but I would really like for you to expand on, what's going on to fix this issue that we have right now.
Yeah, so over the spring, everyone realized what was about to happen, and especially those who were concerned about the needs of the most catastrophically injured. They realized soon we're all going to be operating under these reduced reimbursement rates. It's really going to jeopardize the care and treatment that these people need. And so a group of people that was connected really through social media to begin with, in a group called We Can't Wait, banded together, and they tried their darndest to make a difference down at the Capitol and tried to make sure that these legislators knew what was coming down the road here. And unfortunately, even though they had such valiant efforts to try to bring about change, that change has not come about as we sit here today. But they continue to try. And hopefully the legislature will realize that they do need to make an adjustment here, but it hasn't happened yet.
Now, I heard, Steve, isn't there a large group of former and current Republican and Democratic legislators who were involved with this that are now saying that we didn't really mean for this piece of it to work like this?
Well, and that's what the public should understand, is that these reforms are passed, and I'm not trying to question the intent of people who voted for them, But many of the people who voted for these reforms back in 2019 are coming out and saying, this is not the result we were looking for. And if I may shift gears to another aspect of this, these are new rules that are intended to apply to people going forward. That's for sure. But the other thing the insurance companies are saying is that these are new rules they can apply to people already in this system.
Meaning
so a lot of
people who were catastrophically injured 5, 10, 20 years ago.
Yes.
Right. That had been diagnosed ages ago that they need 24/7 care. Now we have new rules affecting them.
Right. And so you have the thousands of people who have unfortunately been catastrophically injured in auto accidents many years ago, receiving benefits under the old rules, relying upon those old rules as really their rights under the law. And they develop care plans around those rights. And now they're being told that everything's been changed for them, even though they bought their policies back under the old law, even though their premium dollars were based on the old rules applying and not the new rules. And so this has been another huge point of controversy. And this is what you hear a lot of the legislators coming forward saying, that they didn't intend for these new rules to apply to people who are already receiving their benefits under the old law. And that's where there's a big fight brewing in the courts. And actually our firm has a lawsuit at the Court of Appeals right now challenging this idea that you can retroactively apply the new rules to people who are already receiving benefits under the old law. And we'll have to see what the appellate court does with that.
Another problem that you raised with it being applied retroactively, are there any, other than the court cases, are anything else being done to fix that problem?
Well, right now, the court cases are the main hope that the appellate courts will realize and recognize that when people buy their insurance contracts, which is what they are, your insurance contract with your insurance company, that your rights are determined based on what that contract said at that time and can't be rewritten by the legislature years later. We hope that the courts will recognize that. There are ways in which the legislature could act here, but they haven't done so. And so, we're in a very uncertain time here with regard to how this law operates. And that's what a lot of this controversy is about.
Now, I think there were some other significant changes that went into effect on July 2nd. Other than, I think we talked about 2 so far. Were there any other changes you can tell us about?
Well, there was the reduced rate to medical providers, and then there's this right that people have had to have their insurance companies pay for their nursing care at home, their need for assistance and supervision in their own house. And many people have made arrangements with their family members and friends to provide that care, and their insurance companies have had to pay for that. Now there's this new rule under the new law that says that if you receive that care from a person who's a family member or a friend or any type of acquaintance of yours, that the insurance company doesn't have to pay for any more than 56 hours a week of care provided by that group of people. It's a bit arbitrary rule. Why do people need to turn to strangers to provide care when they can rely on family members and friends? So it's another point of great controversy. And again, the insurance companies are taking the position that this new rule applies to people who are receiving benefits under the old law. So I've talked to people across the state being told that their arrangements with their family members and friends to provide care are now going to be changed under this new rule, and the insurance company is going to limit payment to 56 hours a week.
So do you have any further thoughts to share with us about where things stand with the no-fault reform system?
I just think we're at a point of great uncertainty due to a lot of things we talked about here today. And I think the system is now more confusing and complicated than ever. And it's no longer about providing lifetime care to people. You can still get lifetime coverage if you buy it, but so many people are going to be without that. And even if you buy it, the system is now so changed that it's a shell of its former self. And I personally find it to be unfortunate.
Well, thank you for shedding some light on these issues for us.
Thank you for having me.
In the Name of Personal Injury Law is brought to you by the Sinas Law Firm.